I now give the floor to Mr. Itai Epstein. You have the floor.
Madam President, Excellencies, on behalf of the Norwegian Refugee Council, I wish to thank you for the opportunity to brief the Council at this quarterly consideration of Resolution 2334. Adopted almost 10 years ago, its words are familiar. Israeli settlements in occupied Palestine constitute a flagrant violation of international law. The question before the Council today is not whether those words remain correct. The question is whether the Council is prepared to give them effect. It is the plight of Palestinian communities we serve, living with the consequences of non-implementation, displacement, dispossession, and the steady erosion of protection that I wish to share today. When states gathered after the Second World War to codify the Fourth Geneva Convention, including its prohibition on population transfer, they did so in the shadow of mass atrocities, colonization, forced displacement, and racial persecution. For Palestinians today, this is not an abstract legal proposition. It is a lived reality. The law saw this danger clearly from the outset. In June 1967, Israel came to occupy the West Bank, including East Jerusalem and Gaza. Within weeks, Theodore Meron, then Counsel of Israel's Foreign Ministry, set out the legal consequences with notable clarity. He affirmed the applicability of the Hague Regulations and the Fourth Geneva Convention to the newly occupied territories, recalled the prohibition on annexation, and advised that civilian settlements in the occupied Palestinian territory would be in contravention of explicit provisions of international humanitarian law. What has changed since is not the law. What has changed is the scale of the breach, the entrenchment of the occupation, and the cost borne by Palestinians for the failure of enforcement. The Council, Excellencies, must bring into view the convergence of phenomena too often treated separately: settlement expansion and settler violence, demolitions and displacement, obstruction of humanitarian relief, and denial of essential services, and the fragmentation of Palestinian governance. Together, they create a system of coercion. Since January 2023, 117 Palestinian communities have experienced full or partial displacement linked to settler attacks and related access restrictions. The displacement crisis is not confined to Bedouin or herding communities. More than 33,000 Palestinians have been displaced from Jenin, Tulkarm, and Nur Shams refugee camps and surrounding areas. As we have just heard, OCHA has described this as the largest and longest displacement crisis in the West Bank since 1967. The figures matter because they confirm the pattern. The home, the school, the water network, the olive grove, and the refugee camp have all become pressure points in a wider effort to make Palestinian presence harder to sustain. One recent field assessment shows what prolonged displacement means for families. Households displaced report worsening shelter conditions, collapsing livelihoods, and fear of repeated displacement. Another assessment should deeply trouble this Council. More than 70% of displaced households identify threats against women and children, including sexualized threats and gender-based harassment, as decisive in their decision to flee. Madam President, forcible transfer does not always announce itself with a single order. It may occur through accumulation, repeated attacks, sexualized threats, demolished homes, lost livelihoods, in the absence of credible protection. East Jerusalem and the Jerusalem periphery illustrate how coercion becomes a strategy for acquiring territory. In Sudan, Palestinian families face eviction and takeover by settler organizations. In and around E1, Han al-Ahmar and nearby Bedouin communities face renewed demolition risk and intense pressure in an area of profound territorial and political significance. Excellencies, the International Court of Justice has clarified the matter before us in decisive terms. In its 2024 advisory opinion, the Court did not merely characterize discrete Israeli practices in the occupied Palestinian territory as unlawful. It found that Israel's continued presence in that territory is, as such, unlawful. It reaffirmed that the West Bank, including East Jerusalem and Gaza, are occupied territory over which the Palestinian people hold permanent sovereign rights. It identified legal consequences for Israel, for all states, and for the United Nations. That clarification matters for this Council. Resolution 2334 rested on legal rules that were already clear when it was adopted. The Court has now confirmed those rules and the consequences that flow from them. Settlements are not only a flagrant violation of international law and an obstacle to peace. They form part of an unlawful situation whose consequences cannot be ignored. What was framed in 2016 as a call upon states has, after 2024, acquired the character of a judicially endorsed legal obligation. The Security Council cannot, through subsequent resolutions, dilute obligations grounded in peremptory norms or negate the legal consequences identified by the Court. From wrong comes no right, and no passage of time cures illegality. This matters, Madam President, because annexation is often described as irreversible. That is a political claim dressed up as certainty. It confuses material entrenchment with legal consolidation. It seeks to turn unlawful facts into lawful rights. Annexation has become more costly to reverse, more complex to dismantle, and more disruptive to vested interests. It has not become irreversible as a matter of law. The same clarity is needed in relation to settler violence. It is often described, including in this chamber, as extremism, as though it were a marginal deviation from state policy. That language is legally inadequate. Where armed settlers operate as integral or auxiliary parts of military forces, or where public officials enable, direct, or exercise control over settler violence, the inquiry cannot stop with individual criminality. The question becomes one of state responsibility. Only last week, Israel's own military advocate warned that violent settlers and the armed forces are no longer readily distinguishable when, without legal authority, they impose restrictions on Palestinian movement. Settler violence may therefore be both individual wrongdoing and part of a coercive environment for which Israel, as the occupying power, bears responsibility. Settler violence forms part of the broader architecture through which territory is unlawfully acquired and controlled. Excellencies, the response of third states has begun to shift, with greater attention to individual perpetrators of settler violence and extremist groups. That attention matters, but individual accountability cannot substitute for the broader obligation of states. Measures aimed solely at direct perpetrators fail to address the roles of ministries, settlement councils, and the legislative and financial infrastructure that sustain the settlement enterprise. States must ensure that their own conduct does not recognize, aid, or assist in an unlawful situation. They must also cooperate to bring it to an end. Madam President, that means restitution first. Homes, orchards, and olive groves must be restored to their rightful owners. Settlements and associated infrastructure must be dismantled. Palestinians displaced by coercion or violence must be able to return voluntarily in safety and dignity. Where restitution is materially impossible, compensation must follow. The General Assembly has shown the way. The UN Registrar of Damage, born of the 2004 Wall Advisory Opinion, should now be expanded to receive claims and quantify compensation for the full consequences of Israel's unlawful presence since 1967, including displacement, destruction, resource exploitation, and denial of housing, land, and property rights. Recognition of Palestinian self-determination without restoration of the material basis on which that right depends will be a promise without land beneath it. Excellencies, restitution addresses harm after the fact. Protection must prevent harm before it occurs. Communities at risk of forcible transfer need protection and humanitarian aid before they are uprooted, not only assistance after injury is felt. Israel has an obligation to facilitate the presence and activities of impartial relief societies such as the Norwegian Refugee Council. The International Court of Justice confirmed this obligation last year. Yet, Israel continues to interfere with the presence, registration, staffing, and independence of humanitarian organizations, restricting their ability to reach Palestinian communities in need and carry out the very activities Israel is required to facilitate. The Council should put Israel on notice. As the occupying power, it must allow and facilitate principal humanitarian action and comply with its obligations under international humanitarian law. Madam President, the obstacle is not lack of law. The obstacle is political reluctance. Annexation persists because its costs remain tolerable to those who sustain it. Subtle violence persists because it is too often dismissed as deviation. Forced displacement persists because the international response remains fragmented. The task before the Council is at once simple and demanding: to ensure without delay the end of an unlawful Israeli presence that continues to drive displacement, dispossession, and civilian harm across occupied Palestinian territory. We are not asking this Council to invent new law. We are asking it to apply the law it has already affirmed. Excellencies, the late Benjamin Ferrance, the last surviving prosecutor of Nuremberg, reminded us that there could be no peace without justice, no justice without law, and no meaningful law without a forum to decide what is just and lawful. The law is clear. The facts are before this Council. What remains now is consequence. Thank you.